Hello guys, welcome to our channel Random Dictation. Subscribe our channel for more dictations on daily basis.
This revision petition is directed against the judgment dated 19/11/1994 passed by learned Additional District and Sessions Judge Allahabad in criminal appeal, whereby the learned appellate court dismissed the appeal filed by the petitioner and upheld the judgment of conviction and order of sentence dated 13/7/1994 passed by the learned Chief Judicial Magistrate Allahabad. By the said judgment, the learned trial court convicted the accused petitioner under sections 279, 304 IPC and sentenced him for the offence under section 279 IPC to undergo simple imprisonment for 2 months and to pay a fine of rupees 500 and in default of payment of fine further to undergo simple imprisonment for 15 days and for the offence under section 304 IPC. The accused petitioner was sentenced to undergo rigorous imprisonment for 1 year and to pay a fine of rupees 5,000 and in default of payment of fine further to undergo rigorous imprisonment for 6 months. Aggrieved by the judgment of conviction and order of sentence passed by the learned trial court, the petitioner has preferred this revision petition. The learned counsel for the petitioner contended that the learned trial court convicted the petitioner for the offence under sections 279, 304 IPC on the basis of the statements of the witnesses, and the learned trial court has erred in appreciating the evidence of all the witnesses because PW2 in her cross-examination admitted the fact that after the accident, when she heard about death of Akhilesh, she reached the place of the incident. Further, PW5 has been declared hostile witness by the prosecution and he did not support the prosecution story. And PW8 also admitted in her cross-examination that after the accident she came out of her house. Therefore, the evidence of these three witnesses was not properly appreciated by the learned trial court as well as by the learned appellate court. And regarding the evidence of PW1, the learned counsel for the petitioner contended that he also admitted in his cross-examination that after hearing the sound of the accident, he immediately rushed to the place of the incident. And further, he admitted in his cross-examination that the deceased girl herself came under the minibus and thereby the accident took place. Thus, the learned counsel for the petitioner submits that the evidence of PW1 also does not support the prosecution's story that he saw the accident with his own eyes while the minibus was being driven by the petitioner in a rash and negligent manner. The learned counsel for the petitioner further contended that as per the site inspection memo and site map, the incident took place on the left side of the road where the dead body of the girl was found 3 feet away from the left side of the road. Therefore, it cannot be said that at the time of the accident the driver was driving the minibus in such a manner so as to drive it in wrong side.